So we were just starting to talk, we were talking about the origins and purpose of intellectual property. We talked about the concept of the bundle of rights and the differences between ideas, tangible expression, and how that becomes a harder and harder paradigm in some respects in the digital age. We looked again at some of the definitions that we started 2 weeks ago in the Copyright Act. So Section 101, 102, what are the definitions, what's the scope of copyright, what are the key exceptions, and we learned about some of the semantics around talking about, say, the Digital Millennium Copyright Act is part of the Copyright Act, and those kinds of details that I think actually cause a lot of confusion sometimes. We talked about subject matter, what is and isn't protected, what is intellectual property broadly, and what is patent, trademark, copyright conceptually. We talked about the idea expression dichotomy, which is part of what we were just talking about again during the break, and about derivative works. We've covered a lot more material. I hope when you see some of these overview pieces, you say, oh yeah, okay, we're covering some stuff. We're making good progress here. We talked about fair use, which is Section 107 in the Copyright Act, and we talked a little bit about 108. And I mentioned I would spend like an entire semester, if I could, on 108 because it has that level of significance on libraries and archives. But not all of you are in the SI program, and even those of you who are in the SI program may not be that interested in that, which is really a pity, I must say. But I'd be glad to have a whole weekend seminar with those of you who are really nerded out about that. But I realize that at least a third of you are in the public policy program or in the business program, and it just may be it may be of less interest. But we did talk about how there are these other exceptions that are intended to support distance education, and that's relevant both for, say, commercial kinds of teaching, and we're seeing more and more of that in the arena of MOOCs and alternative kinds of uses of the internet. There are fair uses, there are limitations and exceptions available to qualified classroom settings, and a lot of the more commercial approaches may not fit into these limitations. And then we also we just started a little bit on print disabilities, and we talked a little bit about the Authors Guild. So before class started, we chatted informally about reactions to last week's reading. And I think these are the key themes that I'm trying to convey in all of this as we move into our conversation tonight. The world's a big place. It used to seem a lot bigger because mail took a long time to get to the other side of the ocean. You didn't ride your horse more than a day away. Like the world was a really big place, and transportation, technology has made it really small. At the same time, the technology is bringing culture into confrontation in a way, that's faster and tighter, and you see the world speeding up in a lot of ways. So where you were able to have time to develop cultural norms about where we agree and where we disagree, we're confronting that much more which at a much higher rate. So you have companies that are doing business in many parts of the world, and they have to adjust both their legal assumptions around cultural expectations, but frequently the legal assumptions in different parts of the world, not frequently, they always reflect national and cultural norms that are distinct in each country. So even though there's commonality evolving through 200 years of treaty conversations in many countries, it's still it's a moving target. So we were talking, remember, around geographic norms for things like obscenity in speech and what's a community norm. You have the same thing playing out in the way treaties are evolving, and how we, as a globe, as a trading community, as a place that has certain social norms around how we treat each other, at least at some high aspirational level, and how we translate that to reality. And there is, both tremendous opportunity, tremendous confrontation, and frequently that confrontation isn't nation to nation. It can be within one country. So, the impact of Twitter on North Africa, on Egypt, Libya, is extraordinary. It's hard to know where these tools, will take things. So I'm not going to repeat all of this, but these are like the aspirations for today, for our conversation now. Really, you did the reading. The key entity that deals with international copyright is the World Intellectual Property Organization. We'll talk about that in a bit shortly. The key treaty is the Berne Convention. We'll talk about that. And we'll talk a little bit about how they function in practice and what the different results are depending on where you're coming from. Did you read the material about the Marrakesh Treaty and the traditional knowledge? Okay. I think those are really interesting because they put into confrontation sort of the haves and have-nots in a really obvious way that doesn't get lost in trade negotiation conversations, which can be very different in tone. How do these relate to different norms about freedom of speech, freedom of inquiry, self-governance or the lack of self-governance? Who has power and who doesn't, and who cares? So we have a lot to do. This is an overview of the readings. This is just a quick checklist. I think you understand why I assigned what I did, I hope. Okay. So let's start really quickly with the Universal Copyright Convention. I know one of you actually read it, and I know who. So who else struggled through, and he hangs his head in shame, rather than the pride of accomplishment. I read the UCC. I wanted a couple comments. Who read it? 1, 2, 3. Okay, be proud. Who tried to read it and just said, this is too boring? Okay, okay. What is she thinking? Okay, from those of you who read it, what were some impressions? Other than this is really boring. Like, did you?
I guess one of the really interesting things, and we talked about this in office hours earlier, was it seems very much like a product of the Cold War. There's a lot of, I'm going to say something from 523, but like half of you were in that class, so path dependency.
Ooh, I like that.
Yeah, it feels very much like it grew out of that kind of mentality, I guess is the best way.
Okay. Okay, who else tried and valiantly struck? Michael?
The one big thing that jumped out to me was how short the term was. It was, like the author, I think, plus 25 years, which is a full half century shorter than it is now. So it kind of brought home, this is a document from the 50s. That's how much longer copyright term has become stretched out, just in really half a century.
What did you say? Path determinacy? Path dependency. Yeah, the treaties set out a minimum. Yeah. So, anybody else? Liz?
I just thought it was kind of interesting as the ways in which the different countries beginning to grapple with the I found also in America the same thing, this whole notion of sharedness. At what point do you begin to think about a world system? How do you reconstruct kind of the intellectual content post-war? So to me, I read this in the grappling of how do we begin to create something where you have country-to-country conversations in this context.
It's actually pretty amazing. I mean, when you think about these conversations in the historical complex. So the Universal Copyright Convention was a creature of UNESCO, which is the United Nations Educational, Scientific, and Cultural Organization. In many ways, the UCC was like an alternative to the Berne Convention. So the UCC retained things like formalities, whereas the Berne Convention, which was, well established and much older, prohibited formalities. So you have very different cultural approaches. You could still participate if you belonged to Berne. There were sort of exemption special treatment provisions. But it didn't really gel very well as a sensible approach. And it really became somewhat obsolete as more and more countries focused on the Berne Convention. Yeah.
Weren't there also some clauses in the UCC that punished people who transitioned from the Berne Convention?
You know, I have read that a lot, and I don't understand it either. And what I've read about it is that it was intended not to punish them, but I think it does. Okay. So happily, my work has not required me to interpret the UCC. It just isn't that relevant. It's one of those things that if you're doing a lot of work, let's say in Latin America, many of the countries in Latin America they tend to belong to both, but they may have a structure that has a pretty strong legacy tied to the UCC for whatever reasons. But I think that's evolving quickly. So the Berne Convention for the Protection of Literary and Artistic Works, just in case you want the whole name, was created, guess where? Berne. Where is Grant's Berry? You know, what is the joke? Grant's tomb? You know, okay. Who is buried in Grant's tomb? Thank you. Okay, so it was originally created in 1886. So a really different world. We're talking over 100 years ago, pre-World War I. But really significant changes in Europe in terms of, you know, you're essentially 100 years past the French Revolution. You're in changing views about government and control and commerce. You have the beginning. You have this idea of national treatment, of mutuality. So the idea was that if you joined this treaty, you had to treat the work of people from other countries at least as well as you treat people from your own country. So there was a disincentive. If you had different rules in different countries and you treated the works from somebody else's country less well than your own, there was a disincentive to distribute, at least through formal channels, from one country to another, because you got unfair results. And when you think about sort of geography and Europe, as much as I'm talking about how big the world is, the literal boundaries between country to country were physically smaller, and in some ways not fluid in terms of like people moving, but certainly fluid in terms of ideas moving and books moving, and not as many other kinds of copyrightable content, if we're talking about that kind of material. So, you know, there's some photography, but that's not really a critical mass. There's some art. That's not something people are worrying about with copyrights. So the hypothetical is like if you're in Germany, anything published in Germany would be subject to German law. But you had to, if you were in Germany and you have a work by somebody from England, you had to treat their work as it couldn't be discriminated against in a lesser sort of way. It also prohibited formalities. So when we were talking about copyright, we talked about registration, renewal, and literally C in a circle or the word copyright. And that was required under American law, just like patent and trademark require it now. It's not required under US law as of our accession to the Berne Convention. And this was as much a philosophical perspective. It comes very much from sort of the Enlightenment and out of the French Revolution, and the idea that the author or creator is inexorably tied to the product of his or her mind. They probably meant his at the time. And that expression requires no formality to be associated with the creator. So it's a very lofty kind of ideal that really, really works badly in the internet age, where you want to be, where to the extent you're trying to be associated with your work, you want either your identity or your commercial interests associated with your work. It's easily separated. Now, I have an idea for, an article I'd like to write. about the idea that, in fact, formalities are actually necessary today if you're a creator in order to maintain your identity and maintain your rights. So you could make an argument about, there's other people who have discussed this idea about having metadata, descriptive metadata or administrative metadata travel with works. And there's already provisions in the US copyright law that says you can't take that off willfully. So, you know, how you associate, the idea of the Berne Convention is completely contrary to the practical needs in some respects of, you know, modern trade and modern creation. Okay, so the United States joined in 1988. And so by 1988, what was going on in the United States is a trade export. By 1988, the United States was generating a lot of intellectual property that had high commercial value abroad. And our copyright, by then, it was life plus 50. You had to register renew for part of that period into the 70s. Europe had gone to a life plus 70, and we weren't members of the Berne Convention. So that meant that when our works, you know, if we'll get to what's called the rule of the shorter term, but even with that national treatment, we weren't members of the club, of the contract, of the Berne Convention that said, okay, we have mutuality. So our works were in the European market, and they had functionally a 20-year, they had a shorter duration, because American law had a shorter duration, and we had no mutuality with, say, England. Okay? So very similar to copyright, some of these concepts, Berne protects creative works in a fixed medium, so it has to be, you know, it's not protecting the idea, but the expression. Copyright's automatic. There are no formalities. Michael was mentioning how the UCC set the baseline originally for life plus 25. The Berne Convention is now at minimum of life plus 50. And there are, for photographs, it's a minimum of 25 years, and for movies, there's more variable work. So 50 years after the first showing, or 50 years after creation if it hasn't been shown within 50 years after creation. So if you've got like a 55-year-old movie that hasn't been shown, you know, that's how you'd calculate. Clear as mud. So I mentioned the rule of the shorter term. So the idea, just like listening to the words, unless the legislation of that country otherwise provides, the term shall not exceed the term fixed in the country of origin of the work. Huh? Anybody want to unpack that one? I know what it means, but yeah.
Doesn't it mean if the work is or if the work was sold in two separate countries at the same time, so two different copyright systems, in the terms are different length, it's the shorter of the two copyright terms is the one that applies. So say if it's good for life of the author plus 50 in one country, life of the author plus 70 in the other, it would be life of the author plus 50 worldwide,
Yes.
Correct?
Yes. So I made this little chart. This is also derived from something with Wikipedia, which I thought was really helpful. So you have a work from country A and a work from country B. I probably should have actually put country names in. So country A has a life plus 70 formula, and country B has a life plus 50 formula. Okay? So if you are in country A, you're going to get a life plus 70 in from either country, if you're Berne members. If you're in country B, on the other side, and it follows, if country B only has life plus 50, you're going to get 50. You're going to get the same term. But if you are in country A and it follows the rule of the shorter term, you don't need to know this. You need to know it exists and that it's an issue. So don't worry too much about this. If you are from country A and you're in country A, you get life plus 70. If you're from country B and you're in country A, you get life plus 50. You get the shorter rule, the law that would apply to make it it brief. And again, this goes in part back to the policy issue if we want work circulating. And in general, the longer they go, most works are not circulating further into their duration. Yep.
So if I'm wanting to convert US dollars into euros, I can go on the internet and plug in the amount of dollars and it will tell me how many euros it's worth. Are there similar things for
Like-
the copyright in 280 nations?
For calculators,
Yeah.
no.
Okay.
There are like copyright genies, that kind of thing where somebody's put together some kind of formula where if you put in pieces of information, it'll give you a number. Have you heard of Europeana by chance? Amazing website. They have a system like that, but they're very careful to make it clear that like you can put in the criteria for a book, but it will acknowledge that that might deal with the book, but it doesn't deal with all the component parts. And this is one of the real struggles, as you know, for trade, but also for copyright, for libraries as well. It would be very helpful. So, bless you. When we were talking, I think last week or the week before, about some of the definitions, and I mentioned that component about national origin, this is where 104A, which is 104 deals with national origin, where, defining who is the creator. You can look this up if you're on your computer, 17 USC 104. Who is a citizen? Who is the creator? If I'm an American and I'm in England, whose law? What is the national origin of the resulting work? So 104A was added to the U.S. Copyright Act as part of the Berne Convention implementation, and it deals with it was further along, but it deals with copyright and restored works, and all of this has to do with who is a citizen or a resident or a domicile at the time of creation or publication of a given work. So these all further complicate predictability in determining whether there is a copyright, what the duration of it is, who owns it. But these were adjustments in American law, in part related to these treaty accessions. Another area where American law, when we were looking at joining the Berne Convention, didn't meet the standards is the Berne Convention includes a concept called moral rights, which is, these are distinct from economic rights. They have to do with the right of reputation. It kind of is sort of philosophically similar to the absence of the formalities requirement in terms of the identity of the author. So it includes the right to have the work properly attributed to you, regardless of copyright. So like if a work enters the public domain in the United States, legally, you don't have to cite the source. It's just public domain. Now, academically or ethically, there are lots of other reasons you want to cite even public domain works in your scholarship. But it really has much more to do with the identity of the author, the right of personality, the right to be disassociated with a work that you may have created if it's been destroyed or altered in a way that you don't feel meets your artistic intention anymore. It can have economic implications, and many of the cases tend to do with works of art. So this is Article 6B in the Berne Convention. American law didn't recognize, is much more sort of economically based, and we didn't have provisions for that. So Congress had this whole conversation about, well, we have trademark law that sort of deals with identity. We have other bodies of law that allow people to associate or disassociate with their work. In general, it was felt that it wasn't adequate for ratification, for joining, for implementing the Berne Convention. So there were some of these amendments made to the Copyright Act. So one of those amendments is referred to as Vera, which is the Visual Artists' Rights Act. And it's Section 106A of the Copyright Act. So it's an act, but it's part of the bigger act kind of issue. It's just a section of the copyright law now. And again, you don't need to know this specifically just to be aware of it and to think of it in terms of like okay, how do we accede to a treaty? How do we find the common areas? What are the compromises nationally within the United States, for example, that have to be made to fit within sort of the national norm, the international norm that's established to facilitate trade or exchange. So while the Berne Convention concept of moral rights is very broad, the US version is really specific. It deals with very specific kinds of expressions: paintings, drawings, prints, sculptures, still photography produced for exhibit. So not like the snapshots you take at birthday parties, unless it's for exhibit, I guess. Reproductions of 200 or fewer copies of things, like a series of prints, formal art prints in a series of 200 or less. And basically, unless you're in the museum world, the gallery world, this affects those industries and creators quite considerably in terms of the threshold of control they have over their work product. But there's explicitly no standard for quality, taste, or value. So if your work meets these criteria, it doesn't matter how bad it is. This isn't about like some aesthetic standard. And the idea really was, what is going to be adequate for the United States to join Berne, meet the mutual obligations, and be able to be part of this trading community. Vera, as I mentioned, is much more specific and narrow in terms of its application and what's available. So there's also this concept of the three-step test. Remember how we were talking about exceptions to copyright, the limitations on the exclusive rights? So while other countries don't have fair use in the same way, and they don't have sort of the same constitutional framework that we have, many of them have exceptions to deal with the interests and values of libraries, of scholarship, of facilitating translation. And so the language of this test, they refer to it as the three-step test. So members shall confine limitations and exceptions to exclusive rights to certain special cases which do not conflict with a normal exploitation of the work and do not unreasonably prejudice the legitimate interests of the rights holder. So basically, if you've carved out a set of exceptions, and those are important within your own national standard, they can't go beyond sort of the threshold that's in Berne. And it's a really, it's a very diffuse kind of thing. And you'll hear people in the United States, when issues around 107 or 108 come up, they'll discuss whether, oh, well, we can't have more exceptions to copyright. We can't have more limitations. We can't be more liberal in the way we create those exceptions because we'd be in violation of Berne. I think that's an argument. There's a lot of people, I don't entirely buy it. I'm very specific in terms of like which argument we're talking about. But the bottom line is that when the United States joined Berne, we had those concepts embodied in 107 and 108. And you couldn't carve out greater exception without being back at the treaty table. Does this make sense? Okay. You don't want to make your economy and your assumptions, say, hugely more liberal than they were at the time you joined the treaty, without it becoming, everybody's going to have different rules, and then you don't have the common area of assumptions. So the three-step test is really, it's a matter for legislation in the countries of the Union to permit, this is in the Berne Convention is the Union, to permit the reproduction of such works in certain special cases. So special cases would be like fair use or libraries and archives or certain kinds of translations, university uses, provided that such reproduction does not conflict with the normal exploitation of the work and does not unreasonably prejudice the legitimate interests of the author. So the author might also be the publisher, the rights holder, whoever holds those interests. And those are the two things that come up actually the most in my work, is how do you apply the three-step test and rule the shorter term. So when I'm going through books to determine whether they're in the public domain as part of the copyright review management system, which we talked about a little bit, you need to know which law you're talking about. So Any questions?
So how often does this three-step test come up in the copyright cases, say for instance, the copy trust or some of the other recent ones?
The three-step test will not come up like in day-to-day work, because it's looking at like what is legislatively appropriate, what should the law do. So, you know, if you're having a policy conversation, and this may be relevant for some of you, and we're talking about, let's say, can we expand the exceptions? So this is something that came up a lot in that Marrakesh Treaty. You know, the issues of people with print disabilities. The question was, did that go beyond what the three-step test provided in a different part of, you know, in the Berne Convention versus, you know, a different treaty in the WIPO. So it's really, it's more likely to happen at that high level rather than, you know, a practitioner trying to figure something out on a day-to-day basis.
So is this something that Jack would have used in helping to argue the Google case for the, in with the ADA, making works accessible to print challenge?
If he was arguing that the law should be changed or addressed in some way, or if he was making a brief to Congress or to the Copyright Office, you know, that's where you would have those conversations. But it's not as, I don't want to misspeak, but I don't see it as something that's part of like your day-to-day practice. Okay. So the World Intellectual Property Organization, sorry about the fuzzy slide. This is from the WIPO website. And WIPO is an international organization, the World Intellectual Property Organization, that governs the international intellectual property system. So that if there's disputes between countries or between nationals from different countries that are not regulable within the law of a specific country, the conflict ultimately will end up at WIPO. It's part of the United Nations. It governs patents, trademarks, copyrights, and governs the overall. It's very much like sort of a combination of the Patent and Trademark Office and the Copyright Office in the U.S. for the world. So I'm going to jump back. We talked about the idea of the three-step test and the exceptions, the Marrakesh Treaty. I want to kind of touch on that a little bit. How many of you read that? Okay, and what was your reaction to that? In contrast, I hope. Did that one kind of make sense? Was that one painful? No, not so much. So what do you think is going on with that one? Michael?
Well, it reminded me of a couple of things. First of all, the How Do You Trust case that we read earlier, and how you can use all of these new technologies to really make written works accessible, much more accessible to disabled people than before. But it also reminded me a little bit of the Americans with Disabilities Act from the late 1980s.
Mm-hmm.
And, you know, there was this point, you know, well, many points, you know, more than a few decades ago, when people just weren't thinking about this in public discourse instead of discourse. And now I think we're finally moving to a point, you know, where we as a society can say, you know, this is really important. These people need to be able to have equal access to these materials. And now I think we're finally starting to see a framework getting there.
Yeah, I agree. Liz?
There was a similar frame, which was within the international context of the International Human Rights Act that would be UN, and I was really struck by the section, reading glasses, but that it was about.
This is like the Universal Declaration of the Rights of,
Exactly,
yeah.
but I was really struck by, so I read it in that context, which was what was happening internationally, kind of recognition and the codification of the human being in terms of rights versus, you know, the contestation that people like my field were against that act. But I was really struck that it framed it in terms of they didn't want to limit the freedom of expression, including the freedom to seek, receive, and impart information and ideas of all kinds on an equal basis with others from America. So I started thinking that all of the package, like knowledge, society, human rights, blah, 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 in a package in this document. I
Yeah.
thought it was really cool.
I agree. I agree. Yeah, I think that Michael's right. I personally see this as influenced by things like the Americans with Disabilities Act. We talked a little bit about universal design concepts and how like our thinking about physical space can and is increasingly associated with our technology. So we have things like assistive design, but we're not as good as thinking. We're working on thinking about them when we come to ebooks and other kinds of things. Also, things like civil rights. So, we've seen things like Truth and Reconciliation process in South Africa. We've seen, we still see tremendous conflict of all sorts in different parts of the world. But I think there is this evolution in terms of a sense of what is possible, and that the marginal cost of those possibilities is relatively low, and it's almost irresponsible not to make them possible. So this is from the Daily, which I just like. They did a piece on HathiTrust. So again, your point related to HathiTrust, one of the things that I can actually envision is a point where HathiTrust actually provides that as a service for libraries, certainly nationally, but maybe worldwide. Because to the extent that we have scans, even secured and so forth, if you have, say, students with disabilities at universities globally, subject to all the right security protocol, HathiTrust could be a means of making accessible to those community. And I can tell you, it's actually a relatively small number of people who are qualified so as far as I am aware, to take advantage of this. So this is not like an open door to infringement. It is not an open door to competing with the private sector. And to the extent, the private sector, to publishers and so forth, are able to make current works available in accessible formats, this becomes less of an issue. So there might be differing markets. I can envision that over time. WIPO and traditional knowledge. What did you think of that one? I'm going to send all you guys home. Michael.
That was something I never really thought of.
Isn't it interesting?
Intellectual property before, and it's absolutely interesting. Because I've studied various indigenous groups around the world, and as in the course of my undergraduate education here as a history major, and almost always when they're coming into contact with colonial and then post-colonial legal regimes, they are not being treated fairly.
No.
And it's very interesting to see this, conceptualization of law as defending their traditional cultures
Right.
and practices
Right.
and things like that.
Right.
But something I never thought of.
It's really interesting. So first of all, it is relatively readable. There isn't an actual document. This has been something. This is a conversation. When I say that there's an intergovernmental committee on intellectual property, genetic resources, traditional knowledge, and folklore, these are conversations that have been going on for many, many, many years. And partly, it's not that there's a lot of disagreement. There's a lot of different national norms. Partly, this has to do with things like genetic diversity in seeds, biodiversity kinds of research, traditional knowledge that's getting used to develop cancer drugs and all kinds of things. If you want to do research on plants or animals in Brazil, they have a whole process now for basically registering and getting approval from the government. As a researcher, you can't just go and set up shop in a forest. It's really interesting to see evolving norms around the commercial value of that knowledge. In other words, it's not just people to exploit, or that if you are going to, it's going to be with a license and provisions and resources back. So it's both like the plants, the animals, the knowledge. But one of the things about copyright is it has to do with the creation of a creator and it has to do with not ideas, but the expression of the ideas. And one of the challenges that you see in this, both in terms of culture, is you have people who want to respect. Frequently, it's people from developing countries, but not exclusively. And this idea of like, what is group knowledge? What is the knowledge of the group? And is that something to be monetized, protected? There have been efforts to like trademark certain kinds of associations, both as a commercial branding thing, but also really to protect the identity of a group. Did you want to say something, Drake?
I totally back this for the genetic resources side of things, but as for the folklore, which I've done some research on, it's tough because the whole sort of field of folklore evolved out of a really nationalistic agenda, and so in that case, it was all about ascribing, okay, well, this particular story belongs to this country, and even though studies show that these stories are getting swapped around by all these groups rubbing against each other, this story is German, and this story is from this Native American tribe, and then others. And so, I don't know, with folklore.
Does this sound familiar? Does this sound like fan fiction?
Well, I had to miss that discussion that you guys gave at the beginning of.
Wait, speak louder, I'm sorry.
I had to miss that discussion at the beginning of class on fan fiction, but.
This is being recorded. You're in luck today.
Yeah, so I don't know, maybe it is. And, it definitely seems familiar as far as the swapping of stories and how easier that is over the internet, because folklore really thrives around communities that could gather together and swap. And now we're seeing those communities formed more than ever before online. And so yeah, I guess there is a real similarity there. Although in that case, it's very nationalistic, and as far as collapsing borders and having everything occur on the globalized level.
It's one of the reasons this is, I think, a conversation that's going on for many, many years, is precisely because of these things. And also sort of like from the museum and libraries perspective, you have a lot of collections that were collected in a colonial time, very exploitively, even like animal samples in natural history museums. Like, I want to say early 90s, the Natural History Museum at the Smithsonian had all the traditional dioramas of lions and tigers and bears. And what the scientists realized, do you know this story? Okay. So what the scientists said is you tended to have in the sort of the taxidermied settings, really large males and really small females. And basically, a lot of the specimens were donated. So you'd have hunters, you have Teddy Roosevelt going off to Africa, and he'd kill the biggest lion, and then, some of the females. So partly you have this like sort of oddity in size, but also the presentation. So if you've watched as much National Geographic as I know, you know that the female, the lioness, is kind of like the one on the go. She's the one doing all the work, and the male is kind of like usually depicted asleep under a tree, and with the cubs like eating, biting its tail. But the dioramas were like anthropomorphic. They would set up the animals as if they were like human families. So the male was like, big and looking to the horizon to protect his family, and the female is like, lounging back playing with the babies, being, the housewife. And so the cost of actually making all of those exhibits up to date was so prohibitive that I think the director at the time or someone on the staff thought of this idea of dilemma labels. So they actually put up labels, I think I'm digressing a bit, but they put labels up saying, this is not how lions actually act. And this scene was created in like 1938, and this was the norm, this is what was being conveyed. And I was working at the Smithsonian, the contracts office at the time, and I, would actually go in museums. What was astonishing is you would actually, people, families are stopping and they're looking and they're talking about the labels, and the mothers are like, see, it's just not like this. The mothers do all the work, even the nurture. But anyway, traditional knowledge. What you had is you have a lot of collections in museums, human remains. So like in the United States, we have the Native American Graves Repatriation Act, or NAGPRA, which comes out of like changes in sort of the sense of ethics and right and wrong and power over, when is a human being a specimen, and when is a human being, and when do we make some really responsible distinctions? This goes, there are a lot of ethnography museums. There's some wonderful ethnography collections. There's like Belgium is really known for these, for some very good collections. But sometimes there are things that are dislocated in certain respects. There have been a number of PhD candidates at SI who have done projects on, there was one student who was doing something on collections at the University of Michigan that were from the Philippines. And they sort of looked at this dynamic, and in many respects, it's an exploitive dynamic. If you were a colonial coming from basically anywhere in Europe in the Victorian era, you took what you wanted. And it creates sometimes museums that are really wonderful, like a lot, there's a really good book, there's several, but one that's called Loot, that's about collections, some very famous museum collections and how material was moved. So it's not just sort of the Elgin marbles kind of situation, but it's other things that are in the Louvre. And every country has their sort of embarrassing moment, and many of them will emphasize how, well, we took this, we received this legally. We had permission from the government. So, it pick your country, pick your combination. It doesn't necessarily make it balanced. And I think what's happening in a lot of these conversations is there's greater recognition about that. So there's questions like, before Mubarak's fall and the Arab Spring, for many years under Mubarak, there was a very active culture minister who was really, I cannot think of his, Zawi Hawass, I think was his name, he was sort of going to museums worldwide and saying, you need to repatriate those mummies, you need to repatriate this, and if you want to keep them, you have to license them. I mean, it was really, many big museums, really wished he would go the other way when he showed up, but generally he negotiated what was desired in terms of sort of Egyptian patrimony. Now, Egypt was perceived as a very stable place, so if you were repatriating, you didn't, it was maybe a loss for your own collection, but it wasn't perceived as like a risk of scholarship. Well, you have a couple problems now. So you have material that's in Egypt, it's only available in Egypt, and to the extent you have religious differences about sort of the pre-Muslim era, you have the risk of destruction of those materials, because a mummy from essentially a pagan era is not relevant to a religious mindset for many people, and this is how you end up like with sort of political extremism playing out in places like about the Bamiyan statues in Afghanistan that were really destroyed, maybe 2001, 2, 3 in that time frame. So there used to be this sense that like, well, we are museums and we are the West and it was like I don't think it was always a conscious, and we are stable, things are stable here, but we can't pass a budget and our government's closed. The Smithsonian's closed. I couldn't get the copyright office website. I thought it was really ironic that the PDF came from the Wikipedian. But so now I know that those copyright circulars, we need to get them on Wikipedia if they're not, they must be there. But all these things are playing out in these conversations, and who has power? So like there's some really interesting conversations going on in Turkey right now about Kurds and their recognition. good, bad, or indifferent, things are shifting in really interesting ways in terms of nations trying to figure out how to deal with differences within their own populations. And I mean, one of the things about the United States is because everybody's from somewhere else, and part of our big challenge and our big opportunity is to figure out how to make it work. Other parts of the world where you have greater homogeneity, whether it's religious or tribal or, you know, different things, the technology is changing that. And I think this is really playing out in these international organizations. I don't know how optimistic I am about like ending up with a treaty, but I think the conversation is incredibly important. So like I have problems with the idea of like I want to be generous and think holistically about how we deal with people and ideas. The risk though, if you look at, well, how do we protect the idea? Like who's the group? Who are we licensing from? What are we limiting? Can you not have fair use if I make a, you know, it's like Salman Rushdie making fun of, you know, being satirical in his work and, you know, not being able to literally show his face because he's put in danger. I'm sorry?
No, the fatwa.
The fatwa, yeah. You know, that's happened several times in Europe. So it's not, I'm jumping off from this idea of the WIPO specifically, but it does have to do with ideas, expression, tolerance. Yeah.
I was just thinking, you know, in anthropology, we grapple with this quite regularly. As a professional body, this is something that, I'm an anthropologist for those who don't know about anthropology, and it's something we grapple with a lot, not only because of the ways in which, you know, the colonial past and the ways in which different countries or different communities have been in conflict, not only physical conflict, but other types of conflict. But one of the things we also grapple with is the question of these kind of revitalization movements that you'll also see all over the world. So I was thinking, as you were speaking, many years ago, I was living in Belize, and Belize had a very active Peace Corps at the time. And one of the reasons it was shut down, and one of the reasons anthropologists got involved, is that a number of the volunteers found it really cool to teach Belizean crafts to Belizean people. And they had this entire heritage production of basket weaving that came about from our own program. And of course they said, well, you know, there's a history of this. So even the question of the ways in which we understand production, provenance, ownership, it's really, really interesting. And the ways in which people nowadays, and I think my own profession, are understanding their own moral, professional responsibilities lies in kind of the freeing of information,
Yep.
or the conversations to have about where does originality come from, what responsibility do we have, what have we done to limit or to hurt people in terms of their rights or to give them rights. And it's been quite interesting. I would say that for the last 15 years, every national conference we have deals with the question of rights and traditional knowledge.
And it's sort of as a scholar, you sort of say, well, if I give the whatever object back to whoever who may or may not actually have an affinity with the thing, the scholarship arguably ends. And which is the greater good or harm? And I don't think there's actually a really good answer. Yeah.
There's a great book called The Social Life of Things that came out like in '88.
The Social Life of Things.
It's one of the first books that kind of thought about the movement, the social network of stuff. And there's a piece that talks about how in the West, one of the things that we've done, which relates to this, is that we start to understand the badge of civilization, the badge of the cultured Western person is a tribal mask on the wall, an oriental carpet on the floor, an Indian carpet and furniture, and it looks at the ways in which we've appropriated cultural artifacts within our own quest to be, you know, worldly and cosmopolitan. And it's really interesting. It's by a museum anthropologist called Igor Khartov.
Okay, it's interesting. I mean, there's a lot of there's like sort of a lot of art historical look at paintings, particularly sort of in the Netherlands as trade was expanding, like to be painted with your. I mean, there's entire exhibits I've seen about like the depiction of Oriental carpets in paintings and how it reflected trade, or like tulips were from Uzbekistan and the Ottoman Empire, and they were being traded through the markets in Amsterdam and were, became a huge craze there. But to be depicted with, a particular flower and a particular carpet showed how worldly you are, maybe how rich you were as a part of a trading class and things like that. There was, yep, Bob?
Yeah, one of the stresses that I feel when I look at this is that there are artifacts that would not exist if a museum had not picked it up
Right,
150 years ago.
right,
And it would be totally
Right.
gone because acid rain and a
Right.
variety of other things.
right. Well, it's there's one of my favorite little gem museums is, what's the Harvard, it's the what, in Washington? The Gardens, Dumbarton Oaks. So it's got sort of medieval things, but what I love is there's these like pre-Columbian collections, and a lot of the material is like gold or fabric or feathers, things that did not survive. And it's so moving. You feel so connected to lives long gone when you're seeing this kind of material. So was there another, Michael, did you want to say something? Okay, all right.
So like Stonehenge was private property until 100 years ago. And people would break up the lintels to use for their building materials.
Right. Well, that's almost like another. That's like architectural fan fiction. It's like you see, like the slabs of a Roman column in the middle of a Romanesque church wall or something like that. So, I think this is actually an incredibly interesting area, but totally unresolved and not going to be. So, yeah.
Mine just in the other than the art history, which of course is fascinating in this, but also the connection that they made to the biodiversity of the plants and animals, that they were tying this whole thing all together, because you could have kind of very easily not done that.
Right.
You could have very easily said, no, we're just talking about
Right.
like traditional candy, traditional
Right.
knowledge. But I thought that the fact that they chose to include them together was definitely really interesting, especially when we start talking about large-scale agriculture and biodiversity in specific. It's a really big.
It's a really big deal, and I think there's a lot of interesting things, and when you think about like the genetics and like essential protection of life or characteristics of life, so you think about that in terms of like what goes into patent and can be owned, but you also think about it in copyright in terms of like what is a fact, what is so essential that it's universal. And the idea of seeds and food being fluid and necessary and human. I think a lot of the biodiversity conversations came from a lot of the medical research and the pharmaceutical research that was going on. I don't know if it was as early as the 70s, but certainly in the 80s, there was more and more of this kind of, the anthropologists realized that the people of the such and such valley never get cancer, or whatever the illness is. Now, aside from the fact that they probably eat 3 ounces of meat a year and don't smoke, or they only smoke certain kinds of things. I think there was a lot of curiosity and a sense that people were being exploited for their knowledge, and that it had pharmaceutical opportunities associated with it. So we were talking mostly about the 108 types exceptions, the libraries and archives, when we were talking about some of the exclusions in Berne and in the Copyright Act, in different arenas. We talked about the 3-step test for national treatment. So the idea that the United States can have a concept like fair use even if nobody else does, but that's part of our threshold of exceptions. Other countries, when you look at their copyright laws, you'll see things like specific kinds of copying for teaching, for universities. The language, though, is much more circumscribed and much more specific. And there's a recent case, I could not find it tonight, so you guys have your computers open, the race is on. Who can find the citation or the reference to this case? It was issued by a court in Madrid in last spring. And basically this was a copyright dispute where I think it was Chesterfield was the author of some famous, some popular mystery novels in the United Kingdom. He was British. And his work, Life Plus 70 in England, it entered the public domain, and someone started to try to exploit it in Spain, thinking, oh, it's in the public domain. Well, the literary estate in England sued in Spain in a Spanish court and said no. For author, Spain has, I think, Life Plus 70 now, but it had a longer period until fairly recently. So it has a grandfathering provision that says for any author who died 1987 or earlier, the formula is Life Plus 80. It stayed under the old law so that you weren't sort of like cheated out of your assumptions, as it were, when the law changed to a shorter term. So the court in Madrid said, oh no, this author I think died in the 30s. There's a few more years, 10 more years on the Spanish clock. So in Spain, this work is still subject to copyright. I can't believe none of you have found it already. It makes me feel so much better because so you end up with like a really weird result. So everywhere in the world, this is in the public domain, except for Spain, and sort of except for the United States because of that GATT restoration thing I was telling you about. So there'd be like an extra term here. So what do you do? If you're trying to make a decision about whether to make a work available. One of the things that we talk about is this idea of localization. And I think we're discussing this during the office hours, but we technically have the capacity to make things available or not to IP addresses in different parts of the world. Although, of course, my laptop has, a US IP address. If I take it on a plane and I do something in China, I can still do it. But I don't know if the service providers in China, I don't know whether there's like still a way of geographically controlling, but Yeah, exactly.
My address becomes Unish whenever I'm in China, or else I don't have access to like half of Google
Right.
or Facebook.
Right, but you don't do anything bad, do you?
No,
never. Bad. 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 Pirating. Bad. We had another conversation before class about the semantics of pirating, and that's because it's such a loaded word. It will bleed into my vernacular sometimes, but what I mean to say is infringement, and so that there's a distinction between those kinds of actions. Does that make sense? Okay. Yeah, Drake.
Some people are reclaiming the word, right? Like they're
I
pirates.
know. Do you want
People are proud to be pirates.
to? Proud to be pirates.
Yeah.
So, are you particularly familiar with like what's going on in Sweden and the pirate party and that kind of like the political movements?
Not too much, but they just want to see. And the Swedish.
Yeah, I mean it's really interesting how like a Green Party would have been like inconceivable and marginal. I still find like the idea of a pirate party to be what? Odd. Like, how is this a political? I do actually understand, Liz. Yeah.
Sweden's one of the homes I'm kind of a little bit like shirking here. Is that, it's not though. In the Swedish context, the pirate party, the Church of Copianism, which is the first church of copying. I mean, in Swedish conceptual, like the cosmology, there is in the
Oh, I'm
social
sorry.
notion of sharing. So, for example, the right to roam is Swedish. There's a Swedish right to roam. So you have the right, it's all in there. So you've got the right to go anywhere you want in Sweden, as long as you don't come like 150 feet off of someone's property, as long as you don't like mess with your cows, or destroy your fields. And so it makes sense in like the legacy of like co-ops as like a regular notion of housing. Like we still share our laundry facilities.
Yeah.
I still have like laundry day when I go home. I still have like cleaning the garden team day.
Yeah.
Solidarity. So I think in the context of Sweden, because the pirate party makes sense. It's like it's an extension. You move from like the right of property and land to the right of intellectual property. To me, it's just like one other step. Even though Sweden's currently becoming much more capitalistic and closing in on those things, but it makes much more sense.
It's expensive.
Oh, it is.
Yeah.
And like the fact that they have a Control C, Control V as like their religious symbol. How awesome is that?
Not everybody thinks it's awesome, but just to say. Yeah, no, I mean, it's harder. I think this also goes to like sort of assumptions of what government does for people, and both power and the economics of making those things happen. Michael?
Yeah, I was just going to say, in Germany, there was a federal election just last Sunday, and the Pirate Party there got 962,000 votes, 2.2% of the entire electorate for the Pirate Party. I mean, that's just mind-boggling being an American, you know, not having anything like that here.
So what's interesting is that like there may be elements of the fact that there's a choice to refer to it as piracy, I think is really interesting. And in some respects, I find it troubling. I maybe 4 years ago, I had a colleague who, he actually now works at Wikipedia, but he was a graduate of SI, and he worked on, this is Greg Kressmeyer. Do you know Greg? Good guy. But he was coming out of school and a certain perspective, and I was far more conservative, and we were talking about like, you know, he's like, well, let's do this program and we can call it, you know, hacking copyright or something like that, and he meant it in the way it's come to be known, which is like working hard on something. And I'm like, we're not using that word, it's loaded, we can do the exact same thing. Now, even 4 years ago, now it is really vernacular to say, you know, hey, let's, you know, hack anything. And it doesn't necessarily mean, you know, break into something. It still really had that sense to me. It's changed. For a lot of people who don't want to hear that word, they really still hear like stealing, theft, bad. Yeah.
I think there is that vernacular change that has already started. I know just from gaming, and because I'm a big nerd, like there, you know, there's the perennial pirate versus ninja debate, and you know.
And what would the pirate versus ninja debate be for those of us not in the know?
So if you generally tend to associate with one or the other, and the ninjas are kind of like stealthy and secretive, and then the pirates are kind of rowdy and loud and, you know, boisterous bunch. So it's something that's kind of been creeping in, I think, and to see it, and once again, I think Europe's just ahead of us on this.
I don't know if it's ahead or just different. Liz?
I went to the Swedish site for the Pirate Party. You know, it's really interesting. They talk about how the need, and they don't mention pirating.
Ah.
It's the Pirate Party. It's about the fantastic information technology of the new modern state, and thanks to the internet and Twitter. You know, I mean, how often do you see Twitter and like a political party statement about us? It's, I mean, I really think, I was interested when you said infringement, because I've never.
Well, when I'm saying infringement, I mean it's infringement. But I think that there's a lot of things that get described as piracy that are not necessarily infringement, and it's like the word hacking and the semantics around behavior.
And they frame it a little bit differently, you know, on their site, which is very much about like the need to have kind of, I mean, we've seen this before, the need to have like freedom of information to trade ideas, and I don't know how to translate this, but I mean, it's, I think it is really different, and I'm gonna have to Facebook my Swedish friends and see if they're like pro or con. Because I actually have no idea.
I was gonna say, I have, so our exchange student, when I was in high school, was from Germany, and he and I have been talking about this, because I'm like, so is this like, if I'm gaming and we're talking about pirates, or is this like Pirate Bay? What are we, like, how's this being conceptualized? And he's like, no, it's more of like a little bit of Julian Assange, and a little bit of nerd, and you know, like, there's a kind of, I think it is just they're a little bit ahead of the curve sometimes on this kind of stuff.
So this is one sec. So first, I read this definition of you know, a religion and I think about the, what is traditional knowledge and what are beliefs and who gets to say.
This is kind of equivalent to Rastafarianism.
Say that again? I didn't hear you. Oh, yeah.
Yeah, like this is like on that level where it's a more of a conceptual model, a mental model than it is necessarily.
It's for a lot of people, it's a system of beliefs.
Yeah, and our tax money can go to support that. Like our taxes can go to the Lutheran Party, or they can go to the Church of Communism.
Yeah, that's not happening in the United States.
No.
And so, taking a different perspective, if you're an entrepreneur, oh, that's an expression. What shocking thing did you find?
I'm looking at the.
If it's not class, yeah. If you're an entrepreneur and regardless of which country you're in, if you want to do business in a given country or globally, these are real challenges. And so one of the questions that is like almost thematic, and we should probably just have a rambling conversation about this, is whether and how business models are changing, and like the whole arena of sort of digital rights management and how effective or not effective they are. It's almost like permitting fans to make creative works. Like, how do you make a living in a productive way? How do you decide what capital to invest in a good or product that is useful and desired? So, I'll do a lot of my research flat out on the internet. Whatever I need for the most part is there. But there are certain legal resources that are authoritative, they are excellent, and I do not have them. If I were affiliated with a law school, I would have them. But their licenses it's extremely expensive. Their license is limited to, a certain part of the legal community. I don't have them at Hatcher, as part of the library, and I don't have them as a scholar. Yeah. And I don't feel entitled. That's the other thing.
I'm in another class right now in business school, and that class is about creativity and innovation, and how just in my last class, we were studying the movement from the traditional approach of localization to reverse innovation, and the traditional
Reverse innovation?
reverse innovation.
I don't know. I've never heard that.
Instead of localization, which the traditional approach is that the host nation, industrialized, rich, will make a product and then modify it a little bit and then market it out in an emerging market. But now the approach is reverse innovation, where they push teams out or stand up and a team in an emerging market from the people that are there, and then develop a product that fits the needs of the people there at a low cost and
Or a cost appropriate to the market.
cost appropriate, but usually it's a less rich country than the host nation. And then they'll actually find demand for it in the host nation. So like all those, like, because they're working like with people that are local and making a product with a team that's already there, like those legal situations, since they have somebody there, they have plenty of like local advisors on the
Right.
team and everything, they're able to, that's just a new model. And they say that they have to have both of those working, cooperating in the new business in order for a business to be successful with all the interdependency.
Yeah, I just because of the kind of gal I am, I'm carrying around in my purse. Department of Commerce, Patent and Trademark Office, National Telecommunications and Information Administration has a request for comments. Remember we were talking about the Federal Register process? I think, did I just think it or did I say it? Okay. I think we were looking at a Federal Register notice in the last couple weeks. They're requesting comments for the Department of Commerce Green Paper, Copyright Policy, Creativity, and Innovation in the Digital Economy. So they issued an inquiry like in 2009. I responded for the university, for the library in 2010. They issued a paper that's online in the last 6 months, I'd say. And so this is another round of cycle of comments. If you're interested, I can put the URL for this, or I'll scan this and put it online. I've only skimmed it, and The deadline is, like mid-October, it's October 15th for the first comments, and there's just no way I'm going to make that. There's a second deadline in November. So they're having a hearing that'll be in Washington to discuss the paper, and they have a task force that deals with this. So who's teaching your class? Okay. I've heard this. I'm just curious to connect with them. But, this is a really significant thing for universities as creative engines, research engines, and all those kinds of things. So you're so hip. You're so timely.
Well, it's relevant. I was like, wow, we were deciding.
Oh my gosh, something in class that's relevant. Right. Anna, did you want to say something? Or are you just waving your pencil? Okay. All right. So, okay, I think we covered this. Okay, so I wanted to just, that's really kind of the formal lecture, and I'm getting better at timing because we actually are like not at the hour. So there's a little more time for conversation, and I was going to do like a couple of the little hypos that were in the earlier, they sort of feel low and not so exciting now with the loftiness of this conversation. But Michael, we can do them or not.
One big general copyright question I want to ask. I don't know if now's the right
Oh
time,
no,
or you want me to
oh
just
no.
read the class.
Okay, no, it's all right, fine.
The patents.
That's fine.
Because I was curious about, all my work on Wikipedia, and the magic date for U.S. copyright law is January 1st, 1923. And since I've been on Wikipedia starting in 2006, that date has not moved.
That's
towards the
right.
present. And I was just curious about this, because this freeze that we're dealing with in reality seems to be disconnected from this idea of life plus 70 that we went to with the Berne Convention.
So can anybody guess?
Is it the 1998 Act, the Sonny Bono?
It's a, when will 19? I'm going to email you this. This is an article by Peter Hurdle. Basically, it has to do with the grandfathering provisions that had to do with term extension. So remember how we were talking about in Spain, you had, there were certain expectations. So you get that longer bite of the apple if it's 1987 or earlier that someone has passed away. It's sort of a similar thing. It's like, okay, we're going to a different formula, an entirely radically different formula that has nothing to do with the event of publication. So there were these boundaries chosen, and 1923 was one of them. So and that's why it's just 1923. So there's this gap. There's going to take a while before we start to get into a sort of a regular cycle of things in their own following into the public domain.
When will we enter that?
I honestly don't know offhand.
Because I know most countries celebrate Public Domain Day, and the U.S. doesn't because of this kind of freeze.
But we should. When that's coming up?
Well, it's January 1st.
Oh, okay. Oh, right. Okay.
So then, another year's worth of work.
Okay. So you want to help me do a Public Domain Day this year? Who wants to do that? Okay.
But, maybe in this country we should wait until we actually get stuff in the public.
Well, it depends. It actually, like in HathiTrust, we do a bibliographic determination so that if you have books that would be, these are tending to be older books. Like if they're published within a certain time frame, each January 1, we will open them and treat them as public domain. Part of what I was looking at I was mentioning the 108 exception and Section H. I find that I talk so much in my job and I talk so much in here that I have a feeling that I'm thinking I've had the same conversations, and it may not have been with you guys. So I was telling somebody about this. This idea that there was that extra section that said in the last 20 years of copyright, libraries had certain privileges to copyright. Okay, that was you. All right. We are calculating that now. And I have numbers for when things will enter that last 20 years and when they would enter the public domain. And we're looking at how to add to our duration, like where we identify something as in copyright, to try to develop the legal assumptions that we could turn into code to make particular dates for when things would enter the public domain. That's going to be further down the line.
Yeah, I was just going to say, conceptually, it's kind of strange because for somebody of my age, I cannot remember the public domain getting bigger. I can only remember it getting smaller.
That's a great op-ed piece.
You know, the Uruguay around and everything that's, but it's just such a fascinating concept to me, and you know.
And until term extension and the Eldred case, I mean, even though there have been consistent expansions, they weren't so dramatic in some respects, you know, and the trade issues weren't so dominant, and you didn't have such extreme results, and I think people didn't expect as much from the public domain. And now we have technology that makes the public domain a much more real, possible, usable thing. I mean, the publishers would re-release public domain books. I mean, there were entire lines of books that were re-released in paperback that were public domain, and it just seems odd that we have like this complete disconnect, and a lot of these are works that aren't being commercially exploited. So, okay. Anything else? Yeah.
So, I don't know if this is going off on a tangent, but,
My favorite.
so we just recently had Verizon and FCC arguments in front of the Supreme Court about net neutrality.
Yeah.
And I feel like that would impact our ability to maintain what we said we would when we signed the Marrakesh Treaty. Because if we go to this model where certain sites and certain domains are able to be reached by some people and not by others, how can we?
I don't know. I think that, you know, it's normal and makes sense to try and make analogies, like as you're dealing with new situations in life in general. You say, oh, is this more like that time that this happened? And that's how law works as well. You know, is this more like, this is like roads, or is this like mail? You know, is this like, in some respects, trying to emulate the existing world is problematic, and that I think that to some extent that's kind of what's starting to happen. And I think we're going to have different systems and different rules, and I also think that is going to, the more complex those rules are, and the less intuitive, and the more confronting they are of people's sense of creativity and speech, you're going to have, I think, two things. I think you're going to have more people ignoring them, and more of this sort of reaction of piracy or hacking, you know, in whatever semantic you want to use, where the law becomes so abstract that it's not relevant, or it confronts people's, you know, social expectations, their knowledge. I mean, one of the things that I see, this is just a really tiny example, but we get emails from people, I think I've described this before, who want me to check to see if a particular book in HathiTrust is in the public domain. So they'll email and they'll say, I'm in this other country, and I think, you know, this person died in this year, and here's 2 pieces of evidence for that, and can you check and open it? So they're not demanding, but they're if it's possible, they want to know. They're very aware that there's a scan there. It's secured, it's locked, it's, you know, if we haven't reviewed it, or it is subject, you know, or it's subject to copyright, it's not available. But there's this incredible global awareness that there's a scan, and that this book, this dissertation on Slavic languages from 1938 is there. And, you know, frequently they're right. Frequently I can open a book, but frequently it's like, I had a situation like that where I would have to go clear rights. I'd have to go track things down, and we're just not set up to do that. That would be, it's something I need to turn my attention to try to develop a framework for doing that, because it's not standardized. And so if I said to you all, okay, here is a chart with the rules for the top 10 countries we get inquiries, have at it, you know, I don't think it would work that well. But if I can kind of standardize it into a set of factual questions that don't require a lawyer to make a judgment call, we might be able to address a lot of these. So Jeff.
Another sort of tangent.
I love it.
You
Okay.
can't copyright an idea.
Right.
And you can't, you can't copyright the idea of a social network, right?
You might be able to patent the specifics of a particular.
You can patent the code, right?
Right.
But you can't patent the idea of a social network like
Right.
Facebook.
Right.
So the case that happened in China was, while Facebook, YouTube, Google,
Mm-hmm.
all of these essentially now very well established prestigious e-giants in the U.S. and the Western world were growing, the Chinese government stepped in, censored, made it so that Chinese people without VPNs or whatever, with Chinese IP addresses, couldn't access Facebook, YouTube, or Google. And then you saw the rise of Chinese clones of those exact same services within, like, the country. I'm not sure how it works out in the context of, like, international copyright, because you technically can't copyright the idea,
Mm-hmm.
right? So technically, the government, like, was justified, quote unquote, the Chinese government was justified insofar that, yeah, we can disallow a service if we feel like, for whatever reason, it endangers, national security, and that's the reason they use it. But it makes it so that, like, you as a country can basically monopolize a sector within the digital economy and profit off of it, like, sort of while exploiting all the, like, between the.
So is there like advertising? It's like a government-run service that has advertising and that
No,
kind
it's
of?
not necessarily government service, just the Baidu, Renewal, Yoku, like basically Chinese clones of their Western counterparts,
Mm-hmm.
all arose like a year or two after those services got really popular in the West. And the Chinese government made it, like, their stance was that, at least on paper, was that we're blocking these services because dangerous elements have been using it to convey information across these platforms. But at the same time, I think they purposely, but they might have, quote unquote, inadvertently, created a model within, like, which is sort of an extension of state-backed capitalism in China,
Mm-hmm.
where the government basically helps them out in the context even of the digital world, which is considered, quote unquote, like, globally connected, which is really hard for you to clone an idea that's already popular because it's already popular. And, like, you can get away with it in China.
Because you can create the market, essentially.
Yeah.
Create this isolated
You-
tiny little
And it's, if you have, no, if you have just China, you're doing pretty good. I mean, that's a lot of people. Partly this is power, culture, norms. They can. I mean, one of my concerns, more broadly, I mean, this is talking about tangents. I worry about how exposed we all are, and how, you guys are really smart. And you're not just inherently smart, but you're really good at following rules, or you wouldn't have been able to, like, compete to be at the top of your classes, to follow the rules, to make your teachers happy, to know how to network efficiently. Those are really good skills, but they're also very conformist skills in some ways. So there was a graduation speech at one of the military academies a few years ago, talking about how our best and brightest are the ones that are the best at conforming, and that our education system is sort of pressuring such conformity and marginalizing, varieties of ideas and varieties of philosophies. And if you're, conservative in one situation, but another person's, not conservative, like the inability to have an exchange of ideas that we're seeing in so many parts of our economy is actually forcing a tremendous homogeneity, which is, this goes to, are we a creative society? Creativity does not really come from homogeneity, and business opportunity doesn't come from that, and sort of a growing confident society. And I worry about fascism, I mean, it's, or forms of it, or, yeah.
When you said earlier that you wanted to write this article about...
Say that again, I'm sorry.
You spoke earlier about wanting to write the article.
Oh, right.
You wanted to write about identity and the ways in which formalities were attached to it. I see this as part of the same conversation, and that we are so used to being self-bureaucratic, and we're so used to different formalities and administrative processes, and I'm sure everyone here has a very full calendar that we regularly update. And to me, this whole notion of regulations and standardizations from formalities, and that it becomes part of who we are in today's world, because that's how you prove things. That's your paper trail, your personal.
That's not new.
Well, I know, but I mean that we are a hyper-administrative society in the ways in which we use technology, and the ways in which, like, SOLs make an imprint. Are they called SOLs here?
Say that again?
SOLs, I think, called here, the standards of learning, the formalized tests.
It's another SOL I was thinking of, but okay. I was like, what did she say? That may be more appropriate, I don't know.
Just the Virginia trip. But like even the ways in which we shut down, critical thinking in favor of other types of standardization and rote. And it is interesting when you think about how our identities are very much bound up to the ways in which we standardize the world around us and what we use and how we do things and we document things. And
It's how we create structure. There's a lot of good things, yeah.
In another class that I'm taking right now, also in the business school, Kim Cameron is teaching that class, and he talks about something that one of the very first classes was fascinating was this competing values framework, but how there's 4 quadrants, and it's like compete, control, create, and collaborate, and how the controls, they all bring everyone to the norm and to the center. And we have standard deviations, and we try to control so that we don't get the negative standard deviations, the things that we don't like about our organizations.
And who is we?
Well,
Yeah.
Whatever that community is.
Yeah.
About community management. But, so we control for those, but to our detriment, because he says that we also eliminate positive deviance. So all that opportunity is lost because we're all conformed to that.
Yeah. Yeah.
I never heard the term positive deviance. I don't know.
Well, there are discussions in communities that deal with particularly education for children with disabilities, things like Asperger's, where it's not a visual thing. It may have a social or a sensory or some other, and the idea that it may be a difference rather than a disability, and that there tend to be strengths that come with some of the deficits, and that there are actually some businesses that are looking at where are the strengths and how do you create the elasticity around the deficits, because some of the social deficits can be unnerving for those who don't have them. Where are the opportunities lying in the variety? One last person. There was a question over here. Okay. You almost did? You want to talk? We're at the hour, but.
We're at the hour.
Okay. Okay. I'll see you all next week. And I'll get everything into C-Tools by Friday. And it won't be so much that you can't easily digest it. How's that?